here.
That might be orange.
Things keep changing, and never for the best, at least not for you. Rearranging rules that we cannot contest. What can you do? Don't go crazy when the judge says your claimant had a good day. When things look hazy, 'cause there's nothing left of 25. Don't get angry, get mad today. We're gonna help you through it all, 'cause you, my friends, are beautiful. We're gonna get you through it all the way.
I'm on the couch, barely.
Good afternoon. Thank you for joining us. My name is Brian Prince, and with me, someone you all know and love, Melissa Day. We're here for... Well, they love you, at least well enough. And we're here for the third installment of our Lawyers and Friends series, which is entitled Changes. So before we get too far into this, I mean, it's an invitational webinar series, so most of you have heard the disclaimer before, but this is essentially attorney advertising. Nothing in here is meant to constitute legal advice, but if you have any questions, please let us know. So, Najee, if you can...
There we go.
So, today we'll be dealing with some recent changes to the post-classification standard for essentially what constitutes time that runs against the caps, as well as the extreme hardship determination that we're just now starting to get some case law out on. So first, a bit of a retrospective. So since the dawn of time, and by time I mean the start of the workers' compensation system, all cases had uncapped benefits, various statutory maximums throughout the year, but as long as that claimant was alive and they still had cause-related lost time, they'd be entitled to benefits. And 2007 amendments came in and they changed all that. They said, oh, $400 statutory maximum? Well, you're going away, and we're going to make that higher to make benefits more competitive to give labor what they wanted. But at the same time, they're going to try to help out carriers by saying, but don't fear, these benefits are no longer forever, they're going to be capped. So the duration of these caps is set forth in Workers' Compensation Law Section 15 and has to deal with the claimant's loss of wage earning capacity, which was then since ostensibly expanded to include both the disability rate and the period, but
Interestingly enough, you realize that the Fund for Reopened Cases, which we both used to defend through Special Funds Conservation Committee work, that was originally set up in order to give carriers, employers, the relief that we no longer have because the fund was sunsetted, where they wouldn't have benefits ad infinitum into the future because it was envisioned that liability would shift after a period of time. And of course, we've lost that. And this legislation wasn't necessarily to redress that because the legislation was passed independently, I think, of the sunsetting of the fund. However, it does give us the same relief where we have some expectation of a durational limit on the PPD benefits.
I mean, it definitely doesn't help with those crippling SLUs, but...
Well, yeah, it wasn't necessarily the best trade we've ever made.
Well, and that's due to the increasing of the statutory maximum. So every year on 7/1, the board comes out with the new statutory maximum rate, which is based on the, is it the median or the mean average weekly wage for the state? I always get those two messed up.
I think it's the average, but I'm not positive. If only I had a bunch of attorneys, I could have looked that up for me.
Oh, like here. Quite. Najee, please. Thank you. So durational cap language is important. It indicates that all other cases implies all cases that don't have a scheduled loss of use in them. So the payment of permanent partial disability benefits are payable for the continuance of the permanent partial disability. However, all compensation payable under the paragraph shall not exceed the amount of the caps. We'll
Oh, behave.
So, yeah, unfortunately, Tyler was going to make a guest appearance, and I guess he has, but he kind of washes out the background, so I should have brought a darker dog.
Next time we'll know better.
Ooh, see, you can see him now. But
It's a Furry Friend Friday at the law offices of Melissa Day, which includes both canines and felines.
But one of the interesting wrinkles on a different case that we had regarding this statutory language is benefits shall be payable during the continuance of such permanent partial disability. And there are plenty of board panel decisions that say that, okay, you're classified. Just because you have a subsequent surgery or something else doesn't mean that classification goes away. So we have at least one case up on appeal now where the claimant's working, he's not getting reduced earnings, but we really want to close this claim. And so our thought, it's already been a bunch of years, let's try to rip the heart out of this thing and take away the indemnity benefits. Because he's been paid nothing. He's working without reduced earnings. Because if the statute's interpreted to be, okay, use the weeks when you need them, then that seems to get that whole duration aspect removed. Because they were classified, they have a permanent partial disability, so why should they potentially 20, 30 years down the road be able to say, oh, I want to use my benefits now? And as I was talking with Melissa about this earlier, it sets up kind of that perverse disincentive, old school 15-8 counting week style, where we're almost begging, please, let's pay you 10 cents reduced earnings. Like, let's have your caps run because of some nominal amount.
It really seems anomalous. So the board has made it clear and has, in fact, decided on this matter that we currently have in front of the panel through its subject numbers, that you're banking the weeks of PPD benefits if the claimant has returned to work and is earning in excess of their former average weekly wage. However, all the case law that's come out on this, as Brian knows, and is talking about with us here today, all these cases really have an emphasis on the durational limits of the PPD benefits. And as a result, it seems like there's a dichotomy that's been set up by the board on how they're treating cases where the claimant has returned to work and they're not counting those weeks where the claimant has returned against the PPD benefit, the durational limits. And I suppose that the flip side of that argument, as I'm sure you received when you got rebuttal papers in opposition to the appeal that we've taken up on this issue, is that the claimant's ability to return to work is certainly taken into account when determining what their loss of wage earning capacity and is reflected in the durational benefit, presumably, because they would have a lower loss of wage earning capacity because they've been able to return to work full duty without any reduction in their earnings. But that's not always the case. And it's kind of a fiction anyway, really.
Well, that, and it's also one of my favorite pro-claimant crazy judges. So that definitely doesn't really help with that idea.
We don't have any crazy judges in this state. That's what I'm talking about.
Well, the important thing is we're not naming names.
True. It would be we'd have to come up with a long list, unfortunately, I think.
How long is the presentation?
Yeah, people have to get back to work. This is just a lunch hour presentation.
So,
anywho, if you're interested in making that argument, we are willing to make that argument, because I think Brian did a great job actually in finding statutory support in other areas of the law for this position that the way that the statute is structured, the limit should be on benefits. Well, it should be it should be a period, a durational limit, not necessarily a requirement that benefits actually be paid in order to obtain the benefit of the limits.
And one of the cases we're going to talk about later, I think, further enhances that idea. But kind of going back to basics, so we got the 2007 amendments, and yeah, they're great. We have these caps, but then it doesn't really help us in terms of a lot of the practical nuts and bolts of how to actually go get these caps enforced. So the first question is really, when do these caps apply? And there's a bit of a, I'm just going to say, I straight up love whoever carrier or whatever firm did the case in Target, because we're going to address this case, WCB number, a couple of times, because a couple different claims, same claim, a couple different times, they're constantly pushing the envelope, and I mean, we can give credit where credit's due, right?
Certainly.
So they try to press this idea of, well, when do the caps apply? When they do apportionment can go back to the first medical evidence of apportionment. It can be at the time of the classification. Who knows? And so they really try to press that issue with the issue of classification, and the board just decided they weren't going to have any of it. That, per the target case, your benefits start, or your caps start, when the claimant's classified, which is kind of weird because, they'll count an opinion of a permanent partial disability as, ooh, that's permanent evidence. So you can't say they don't have evidence of an ongoing disability, but not for the purpose of, actually running the thing that would stop the benefits.
My understanding of the way the board is interpreting this, I just want to make sure that I'm clear on this, is that although the caps don't start to run until the claimant's been classified, that need not coincide with when loss of wage earning capacity is determined. So in fact, you can get a bifurcated ruling from a workers' compensation judge finding that the claimant should be classified with having the permanent partial disability and then have a subsequent determination as to what the loss of wage earning capacity is, such that the caps would go back to the date of the classification with having the permanent partial disability, which might not necessarily coincide with when the durational limits are determined.
Correct.
Okay, great. Good. I know something.
But, so then after that, the firm on target decided to press the issue some more. Najee?
And can I just double check again?
Go for it.
I want to know, for purposes of our presentation here today, the reason that this is the standard right now is because this is what the board panels have said on this issue. There has not yet been an appellate division decision on this issue.
Well, and one might be coming, but this is also the retrospective section. There have been some recent changes that have kind of worked at least some of this out.
Okay, thanks.
Actually, not so much that issue, but some of these next issues, such as what about the case of reclassification? I remember back when I was still at special funds and had some 15-8 cases, because you could have, based on the start date of the caps, there were actually some 15-8 cases that had capped benefits. And so, very narrow window from like mid-March to July, but technically they did exist. And so the question was, we have these capped benefits, they've gotten some benefits, then they had a surgery, and then they were getting some TT, some TP. So when they get reclassified, they should just all of a sudden get that number of weeks again. At least Clements' attorney is pushing it. And in Target, they said, no, you were classified on this initial date. So that's when the caps began to run. If you got reclassified and it increases the number of weeks you got, you still start from that first date, and they went and they carved out a bit for TT, which I'll get into. Which, it was, I want to say it's rather nuanced, but it's good the board just didn't decide to whack us upside the head on this one.
And I guess that's probably a little bit different than the way they treat subsequent claims where the claimant gets classified on a later workers' compensation claim. Isn't that true? So you get classified on a one workers' compensation claim, return to work, have a subsequent injury, which leads to a subsequent classification. And it's my understanding that the board is going to use the date of classification, the finding of permanency on the later claim to determine when the caps run on that later claim. And so if there's apportionment back to the earlier claim, that carrier is not going to get the benefit of their earlier start date. Or is that something that's not yet been decided by the board?
Well, it didn't run into anything that I actually took a look at for this presentation, or frankly ever. But I'm thinking that the caps on each case would run independently, because it's the right to benefits on that file. And so doing otherwise would, I think, artificially inflate the carrier or the
certainly be a good argument based on what you found on the reclassification issue, because the earlier carrier would, I think, have a strong argument that the subsequent classification on the later file is, in essence, really a reclassification of their permanent partial disability, such that the reclassification date shouldn't apply to them for purposes of determining whether or not the caps have run.
Well, at the same time, the carrier in the first case could have had a 15% LWAC, and so they could have had in theory, they could have been paying reduced earnings the entire time. Their caps could have run, and so just because the claimant has a new subsequent disability, if it's apportioned back, should that mean that everything they've paid means nothing?
Yeah, it doesn't seem like that would be fair. And there are certainly tons and tons of variations and permutations on this theme, which we just don't know the answers to everything yet, because number one, the board hasn't considered every possible permutation, and number two, I wouldn't necessarily agree with the board's position even if they did until we have a ruling from the appellate division.
Well, as I was going to say, it's like the board? Fair? But
Sorry, I don't mean to interrupt.
you do. We permit it because you're the boss. You run
I'm
the
just
show.
glad I'm in a show with you called Lawyers and Friends, although I'm starting to suspect maybe the puppy is the friend and I'm just the lawyer.
Well, you just like the fact that you have puppies curling at your feet.
I do like that a lot, I gotta say.
So, which then brings us into my next slide and the next issue is to what actually counted against the caps. So, we run over the language initially. It said ostensibly benefits paid during that permanent partial disability. So, based on the reading of the statute, we had that question of would it be just the PPD benefits? Would it be both, all partial disability benefits? Would it include, temp total? How's this really going to shake out? And so, again, target. It's still that same prior board panel decision from the last slide.
Same claim, but a later board panel decision.
Correct. Same one from the last slide. Somehow the board decided to read into it, and they brought up all the case law, which indicates that just because you've had a subsequent surgery, your permanent partial disability doesn't really disappear. And so they then used that to kind of conflate temporary partial with permanent partial because you have a partial disability, and so apparently all partial disabilities are the same for counting against the caps. But if you're temp total, then that should be something different entirely. And sadly, that was the standard.
But that's changed, hasn't it?
Yes, that's we're on the retrospective. See, retrospective. But I know coordination in the mirror. It's not necessarily my best strength, but thankfully, web presentations are. Najee, if you please. So then we started to get some more case law. We had caps kicking in, and we had the interplay between the caps and the TT benefits, which don't count against them, which was then the principle of tolling. So one of my favorite cases on this point is Heritage Centers, where a claimant was classified and had subsequent back surgery. And the initial caps gave them a durational benefit of, I think, 300 weeks. And so there was about 11 weeks of temp total after the surgery. They were really good and really quick getting clinic cut down to a partial disability. And the board panel held that, those 10.6 weeks were carved out from the caps. That's when the caps were told. But otherwise, you go from the start, plus the 300-week caps, plus that 10.6, and benefits, the caps would have run on 11/15/2017. That's because it's my birthday. And so because of that, not because it's my birthday, because the caps would have run, the carrier was actually entitled to suspend awards. And the judge properly found that yes, you're still trying to litigate reclassification, but as of right now, the caps have run, and so you don't get any further benefits, at least until that redetermination.
So there's no incentive then to argue that you have a temporary total disability following classification, unless you're also concomitantly then going to argue that you should be reclassified, your level of impairment should be reclassified.
Can I ask a question to the team?
Sure.
I have no clue who that is, but sure.
This is Jeffrey Conway. Hello, everyone there.
I knew that was Jeffrey Conn.
Hi, Jeff.
So, hi there. So my question is, I have a bunch of claimants who would be classified, and because they have a lumbar spine injury, haven't had surgery, they've gone back to work. Can you just give a little conversation about why is it? I think it's always good to, get them classified. And I just don't understand the concept. I classify them while they're working, so that means if they go out again, I'd repay them. But if I had, say, 300 weeks, if they're back to work, doesn't that 300-week calculator go lower as they continue to work, like these classified while she's returned to work? Can you talk a little bit about that?
Well, I think there are a couple.
Did you hear his question? Can you articulate it for everybody for those who may not have? I heard most of it, but I didn't hear quite at the end what he was specifically looking to address.
And Jeff, please, if I don't capture the whole, because there's a bunch of pieces that are in there. If I don't capture the whole shape of it, please, feel free to let me know. But essentially, Jeff has a bunch of claims where claimants have back injuries and they haven't had surgery and they're back to work. And so the idea and the concept behind going and getting them classified so that essentially on the back end, if they lose time again, it'll run against the caps. Is that about the shape of it?
Yes, because I'd always thought that if I classify someone, if she's 300 weeks, she's already been out of work, she's back to work, and now we say, okay, instead of posting a reserve to settle the claim, why couldn't we get her classified? And then I thought the 300 weeks would tick down for every week that she's working. And if she goes out again, then of course we could reinstate benefits. But it'd be interesting if we could actually have someone classified and say she never has surgery, never goes out again, essentially with the 300 weeks timed down and clocked down to 0. Would that happen?
Well, and that particular shape is the case that we have up on appeal right now.
The board does not agree with that position right now. The board gives people, they're allowed to bank their weeks of capped benefits if they've returned to work and they're earning in excess of their former average weekly wage. So that doesn't count against their caps.
However, there are some really good reasons why you'd want to classify a claimant while they're working. Because when the board looks at your loss of wage earning capacity, they look at transferable skills. They look to see if you're working, if you can actually work with this disability. And I know Rob's got a bunch of cases where he got 15% loss of wage earning capacities on people who were, they're back to work. Yeah, they had a mild, orthopedic disability, but they're back to work. They're not losing time, and so they're entitled to something. But now's the opportune time to try to get that number set as low as we can.
True, I agree with that. Plus, it's going to allow you to limit their maintenance care with a chiropractor, with physical therapy. I also think you're in the best position at that point medically to potentially get a finding of no permanency. I know that it's the unicorn of comp to actually litigate a file and get a finding that there's no permanency, but I also think that's because we've stopped hunting unicorns. So
I've gotten one.
Excellent.
It was a hand schedule loss used the full range of motion.
Right.
Board.
Right. And I think that people don't really fully appreciate that a finding of no permanency, I think, is something that's contemplated by our new guidelines, the board's kind of new attitude. Certainly with the schedules, I think that we are rife with opportunities to get findings of no permanency. But also, if you're going to get a finding of no permanency, what better time to do it than when the claimant has returned to work and it doesn't have any restrictions on their ability to work. So you're either getting the classification and the benefits of potentially the classification, either with treatment or if we are successful in our position that the week should not be banked and that the durational limit should start to run regardless of whether or not the claimant has returned to work full duty. Or the alternative is you might get a finding of no permanency. So I completely agree that we should be litigating classification. We shouldn't just let those files close. We have instances now in our office where the employer allowed the claims to just, they close, reopen, and it's been 10 years now, and there have been periods of lost time, coincidentally during the summer when it's super nice out or during hunting season. But none of those periods of lost time have been running against any cap because the person's never been classified. So on those, I would like to go back and start to litigate when permanency should be found. And I understand that the board has taken the position that permanency, that the caps don't start to run until the claimant's been classified. But in a case like this where it's 10 years old and the employer has already paid maybe 200 weeks towards what could have been towards a PPD durational limit, then it's going to be worth it for them to expend the money to litigate that issue, potentially up to their third department.
So then a quick question, and thanks for that response because at least it gives us an idea. So in that claimant, I really should probably be pursuing, tell our defense counsel, let's look at classification because, I think she certainly could have low back surgery, and I think this would be a good, example case for my caseload because I have other cases like that. And why not do it on an easy one? She's working, she's earning a regular salary, she still has her attorney on the file. Her medical care has somewhat ended, but there is some sort of, black hole out there of what her indemnity would be. So I have to I would have to, as an adjuster, assess that amount, saying, okay, I anticipate her classification, and it probably could be low because she is working, so there's no loss of wage earning, but there is still some exposure. I have to understand that to get it right. Is that about right, Melissa?
Yeah, yeah, and I mean, my feeling is too, maybe there is some very minor loss of wage that you could avail yourself of as an argument in order to make those weeks count, right? Because the way we set average weekly wage in New York is it tends to generally sort of artificially inflate the individual's earnings at the time that the average weekly wage is set. So it's not beyond the realm of possibility that they could return to work full duty without any restrictions following an injury, but have reduced earnings because their average weekly wage was set a little bit higher than what was actually economically true with respect to that person's earning capacity. And so when they return to work, they might have a $10 per week reduction in their earnings, which you would want to take advantage of because for sure the board is going to find that that week counts. And so we'd be in this very interesting position of arguing for reduced earnings where claimants' attorneys are going to be arguing against reduced earnings. So I can just see a myriad of possibilities as to why it might be beneficial to you to want to litigate classification versus not litigating it.
Well, and in the same vein, the board is almost, I want to say cravenly, into inflating the claimant's average weekly wage. Because I had a situation where, okay, we're all in a situation where they worked like 255 days. Oh, use a 260, they're entitled to it. That's like that first measure per section 14. That's how their average weekly wage should be set, right? Work substantially the whole year, 5-day worker, yada, yada.
I'm sure this has never happened to anybody in the audience.
On the other side of the coin, though, okay, they work 265 days.
We'll use divisor.
Yeah.
Yeah.
I specifically had a case where this last week, I was like, Judge, this is a 14-1 situation. They work substantially the whole year, 5-day worker, 260. Well, the judge actually found on the record that using the 260 multiple artificially deflates the claimant's average weekly wage. I'm going to use a 52-week divisor. And
that's a good issue to appeal, actually. I'm sure you know.
Well, the difference in the average weekly wage was like $2.
Right, but if you extrapolate... Where's the desk? I need to pound on. If you extrapolate that over the lifetime of the claim, you might be talking about the difference of $5,000 lifetime over the course of that claim. Is it worth it to file a $500 appeal on that particular issue? I think it might be.
But we don't know.
Right.
That's a judgment call for you. Always happy to help.
Right. Well, and then again, if you, so Jeff, I think that it's going to, and this goes for everybody, I think you pick your battles, if it's a case where you have high exposure or the claimant hasn't returned to work for you, it's going to be hard for you to keep track of what they're doing. You want to push settlement because that's going to be an option because they've no longer returned, they're not at your employer anymore. You don't like them because they called you up and swore at you on a regular basis because you weren't giving them their opioids. For a variety of reasons, you may decide that for that particular case, it's worth it for you to aggressively litigate the issue of classification.
Well, and your issue of surgery after classification, I'm going to put a pin in that because that goes right along with the recent changes, which I think might be the next slide.
Thanks very much.
So, I'm right, yay. Jacobi Medical Center is the new standard for what counts against the caps in terms of classification. So, and again, it builds on that whole concept of how your classification, your permanent partial disability doesn't go away because you had surgery. I mean, I know in other places surgery actually makes people better, but apparently not in comp
land.
So
I guess I kind of skipped ahead earlier. I sort of ruined the end of the story, and I apologize for that. The board used to treat it so that your TTD, your temporary total payments after classification, did not count against your durational limits. The board has subsequently, in Jacobi Medical Center and in its progeny, or perhaps earlier than that, decided that temporary total disability benefits should count against the durational limits.
Well, she's a woman ahead of her time, but as George Carlin said, only about 5 minutes ahead. But no, Jacobi Medical Center actually does one better. It says there's no temp total disability after classification, period. You're classified, you have that permanent partial disability. That disability doesn't go away. Unanimous board panel decision. So If they're going to take it, it's going to go up to the third department. But that means temp total, gone. They get their classification rate, or they get the reduced earnings rate if they're working. That's it.
And so they don't go up to temporary total rate even when they have surgery.
Correct.
Great.
So bring that back to Jeff's case with the claimant who's currently working now, back injury, hasn't had surgery. If you think surgery even might be a potential, get them classified now. That way, you're stuck at that low 15%-ish LWEC rate after you have your surgery, and we get to count those weeks. You're winning twice.
And that's if they set the LWEC, if they use LWEC to determine wage earning capacity, because as we know, those are two different concepts, and so.
Which rely on substantially similar factors and
Correct.
typically tend to coincide.
Right. So you could end up with that would be a massive disincentive for a claimant to end up going back out on surgery related to your workers' compensation claim if you got a very low loss of wage earning capacity, which coincides with your wage earning capacity, because the person's going to be limited to a 25% rate even though they go out for surgery.
So while it might actually not prevent them from going out, it'll certainly get them to have their doctor start giving them restrictions, start coming back, so they can at least get more, per light duty than they would have gotten in based on the classification.
Or they'll have a new injury, depending on where they're working, that could work out for you, that might not work out for you.
Oh, like the new injury claims after you've stopped working, like I have one of.
Well, that's going to be fun. You're welcome.
But, and Najee, if you may. But I know Rob's talked about this at some of his other presentations. I'm not sure if he's ever talked about it here with lawyers and friends. But, pretty soon we're going to be able to start counting against the caps weeks of benefits that we've paid in excess of 130 weeks. So
this is a big difference.
Correct. So not only, Jacobi Medical Center was great by itself, combined with this.
A statutory change.
Correct. It is just, I don't want to say it's a windfall for us, but it's kind of, given the schedule losses of use, we deserve this. So not only after you get the claimant classified, do they not get TT rate, they don't get a tolling of the caps, but we get to count any benefits for claims that are after 4/10/2017 date of accident. Any benefits that have been paid after 130 weeks from the date of injury. So they could have had no lost time until 131 weeks. We get to count it.
So that's presumptively a week paid against your permanent partial disability durational caps, even if the claimant isn't classified yet.
Correct. And that'll obviously kick in when the claimant gets classified so that you know when to stop the benefits down the line. But that's also a statutory retreat from that whole idea of, not explicitly, but the whole idea of it's not fair to have claimants have their caps run before they're classified. And that's the rationale behind that first target case of, well, no, we're going to start the caps as the date of classification, and this rule doesn't change that. It just says, well, after a certain amount of time, go or get off the pot.
Right. It's a presumption. The statute did is create a presumption, but this time it's in our favor. Presumptions are generally have been in the claimant's favor. But this one is there's a presumption that all payments after more than 130 weeks after the date of accident are benefits post maximum medical improvement and part of the durational caps or permanency of benefits. So this is, and the claimant can refute, as we know from the statutory changes, there is a safety valve, that's what it's called.
Correct. But of course, it requires them to get medical evidence kind of contemporaneous with about the ending of that 130 weeks.
And to litigate it.
Yeah.
With medical evidence.
So you can't just say on the back end, oh, but I wasn't permanent then.
Right. So it's going to push, and we're not saying, obviously, there is a safety valve. Claimants are going to be able to litigate whether they're at MMI more than 130 weeks after the date of accident.
And they will try.
And they will likely succeed in some instances as well. But it's going to push, it should push everything earlier. Now, for those of you who face ATF deposits, you need to be aware of this as well, because it's going to push classification earlier. And so if you do have to make an ATF deposit, it's also going to have you face that potential liability as well.
Yay, liability.
Well, that's
But-
why we're here. We're here, friends.
Hey, how about one more question?
Sure, what's up?
Do you think the ATF will ever really go by the wayside of the dodo bird, or is ATF going to be around for the rest of my life?
Well, as far as I know, all the litigation challenging the requirement that the deposit be made has been exhausted. There was a push a couple of years ago to change the statute, and that ultimately failed, although it was on the brink of getting passed, and I can't remember what led to its downfall. But I have not seen that proposed again as legislation, and given the benefit that it's led to for the increase in the value of settlements for claimants, I would anticipate that the Injured Workers Bar Association and the Workers' Compensation Alliance, which are two lobbying groups that support legislation, that's going to benefit claimants, given how demonstrably effective they were in fighting the proposed schedule loss of use, the amended schedule loss of use guidelines, which were issued initially. I'm not super optimistic that we're going to get that legislation, that legislation would get through. So the very long answer to your question is it's here to stay.
Well, at the same time, just because you brought up the 25A fund, kind of the reason that one was because of frustration of purpose. And so, the whole idea behind the ATF is essentially to protect claimants from carrier insolvency, because that does, occasionally happen. But, from the same turn, if all of a sudden the ATF isn't getting any fresh money in because all the carriers go on and just, I don't have to pay this, I'll just pay the claimant instead in some other cases, then the legislature, who doesn't really know what's going on that much from the day-to-day in the comp system, might say, I guess we don't need this anymore. It's just, an extra cost dragging the bottom line. And
yeah, except that I think that it's a source of funds that could be rated for other purposes. So I'm not, and I certainly can. I cannot refute your logic there that. The Special Disability Fund was originally set up to protect World War II veterans when they were returning from war so that they'd be able to find work, but not also, bankrupt employers who wanted to hire disabled veterans as they came back. And then with the advent of the ADA, that supplanted the need for these workers to have the protections that the Special Disability Fund was set up originally to help redress. So I cannot refute Brian's logic on that eventually the purpose of the ATF and these deposits could ultimately become archaic. I'm just not seeing it at the moment.
Well, wait a second. You're saying our government raids various state agencies for funds?
It's our fault. We're the people. We elected them. They're there.
But
Thank you again.
you're welcome. And I believe the next slide.
No, nothing.
Okay. The next slide should take us to the extreme hardship provisions. And it always makes me think of this stupid internet meme. Because essentially the boards come out and said, this isn't just any old hardship that you have to have in order to get this release from your number of cap weeks. It has to be an extreme hardship. So,
And you have to love it when a court or an administrative agency goes to the dictionary to look up the meaning of a word in order to reach a decision on an issue, which I noticed that the board did.
it's like words have important meaning.
Yeah,
Who didn't
I don't
know?
want to steal your thunder again, so I will leave that to you, but
Hey,
I did read it.
if it's my thunder, you've paid for it, so go ahead. But, Najee? So, Section 35, subsection 3 is what gives us this.
Extreme.
So, gives us this extreme hardship determination.
No, extreme.
Hardship determination. And so, first of all, we all know that you have to have a LWEC of greater than 75%. Keyword greater than, not greater than or equal to. And it used to be 80, but they dropped it to 75. And it is what it is.
I
But-
actually had a claimant's attorney agree to a 75% LWEC after they changed the law with me because he thought that it was 75% or greater. I did not disabuse him of that. Not my job.
Again, words having important meanings, theme for this section. But they also have to be currently receiving their indemnity benefits, and within a year prior to the expiration of their cap, they have to apply with the special board form, and they can then, if they're successful, get reclassified at a permanent total or total industrial disability, which, based on some of that language from Jacobi Medical Center, would be bad because, again, that's total for the rate as well as, at least in theory, the duration, which for total disability is uncapped. So,
did you find anything when you were preparing for this presentation on whether or not if somebody's out of the labor market, those weeks that they're out of the labor market count against their durational caps?
I didn't look for that. Did you?
I did not see anything, but as we're sitting here talking about this and the standard being for applying for the hardship redetermination that you actually have to be currently receiving benefits and then you apply within 1 year of the termination of those benefits, that if somebody was voluntarily or they were not attached to the labor market and the weeks were counting against them, they could be within a year of the termination of their caps. But because they're not currently receiving benefits, because they've been adjudicated to not be attached to the labor market, they would not be able to avail themselves of the extreme hardship redetermination.
I mean, Naj, if you please, that's my reading of the subject number. And that would also apply in situations where they're not necessarily unattached, but they're in prison on a felony.
Mm-hmm.
So the board has set forth the requirements of what they need in order to have your extreme hardship determination. So you have to have PPD greater than 75%, be receiving your benefits. They're very explicit in the statute about that, or the subject number about that. You have to be within a year of the cap ending. So of course, read in conjunction with the previous sentence, they have to be on the receiving benefits side. It can't be afterwards. And they have to complete, again, important word, the board's C-35 form and submit it within the time frame.
Has to be accurate and complete. And this is all really good news for us, I think, the way that the board has been addressing this so far. And I'll allow I don't want to step on, again, I don't want to steal your thunder. But,
okay. You've also read the slides. You know where this is going.
True.
But one of the interesting things...
Happy ending.
Wow. Not going to touch that one. But one of the interesting places that this was in this case, Jewelry Box Corporation, where claimant entered into a lump sum, like an old lump sum settlement like a long time ago, and they're just throwing everything they can at the wall trying to get this thing reopened, get some benefits. And they actually tried to use, for one of their arguments, extreme hardship determination to get benefits again. The board's just like, no. This only applies in capped cases because it's about lifting the caps. So at least if you have an old uncapped case, you don't have to worry about there being an extreme hardship to try to reclassify someone up to the total rate.
Had that person received a lump sum settlement?
They did.
Oh, interesting.
And also in this board panel decision, they got a finding of 123, my favorite finding.
So the board really stuck it to them on that one.
Yeah. The board being no nonsense for once.
Yeah.
But speaking of no nonsense, Najee, the board's C-35 form, I'm not sure how much of this you can read, but it's legit. It requires not only all the financial information for the claimant, but also for their spouse and for any other adult who lives with them. So if they're, like my friend Will, the kind of person that has 5 roommates who give him money and pitch in for things, arguably those are adults who are living with him. Will's also not my child claimant. He's working. He's at work right now. But
so he's not watching this, so he can't be mad.
Correct. But at the same time, it's setting forth completely all the information for all of the parties, as well as your expenses. And one of the other important things is this box here, other factors that contribute to the extreme hardship. So right now from above, we'd have what their expenses are, what their income are. But it's that additional box that sets forth, why is this an extreme hardship for you?
Opens up a new avenue for fraud that we have not litigated yet because there have only been a handful of these cases because of the caps, basically. These cases that were capped are just starting to now qualify for possible extreme hardship redetermination. But this is, if you have 20 people living in a home and the claimant says it's only him or her that lives in this residence, your surveillance companies can help you refute that that allegation on their C-35 by demonstrating that it's clear that there are additional people living at that location.
And the good thing about this is, though, at least, while there's a potential avenue for additional fraud, the claimant has to set it forth at the outset. They can't just be at the hearing and say, oh, and my extreme hardship is all these things, and the employer has no time to check. We could check this in advance. But the important thing is also, it's not just setting forth what the things are. They have to provide the evidence to support their form. And so, Najee, if you please. So, and one of the things, the upper section of that form was income from all sources. And this kind of harkens me back to my days in family law, where, the courts will go, and especially in child support, which is what DRL Section 240 is for. I hope none of you know that, but if you do, you know that they're rather zealous in terms of trying to find as many things as they can consider income to help those kids. And so they include essentially everything that should have been on your tax returns. So income from working, investment income, and then income from just all these other sources like workers' compensation, disability, unemployment, Social Security, veterans benefits, pensions, retirement benefits, fellowships and stipends you might not see for like the claimant or their spouse, but if they have other adult children who are living there doing grad studies, annuity payments, and some of your older people that didn't receive the best financial advice, or won the lottery, who knows. Perks and fringe benefits from employment, like if your employer pays your health benefits, that could in theory be imputed as income, or in this case potentially someone's spouse or stuff like that. And also, at least in that context, money, goods, and services paid for by other relatives and friends. I mean, I don't do this, but I'm going to throw a lot of millennials under the bus. How many of them are not paying for their own cell phone plan? They're on their parents' plan, and my producer's kind of giving me dirty looks right now, shaking his head. But so at least in the DRL 240 section, that could be imputed to them as income, in addition to spouse support and stuff like that. So there are a potential plethora of sources for both the claimant, their spouse, and anyone else who lives with them who's an adult to count as income for our purposes. And Najee, if you please. As I mentioned when I was talking to Melissa, they have to be complete with these applications. So Lincoln Hospital is one of the few cases that I found that actually dealt with this head on. And in that case, the claimant had an adult child that was living with them. They didn't include any of that information.
I'm allergic to millennials.
We employ a hell of a lot of them.
That's why I sneeze all the time.
Couldn't be the office cat. But so because they didn't include that information, they found that the form was incomplete and they wouldn't consider it. But they also went and, actually, I think that's my next one. The thing that I don't like about this case is that they didn't come right out and say, you submitted this form, it's too late to do so now, it wasn't complete, we're not going to consider it. It said that the case may be reopened upon submission of the required documentation consistent with the provisions of the statute, which, to me, as the carrier side, I would argue, okay, there's a deadline. If you didn't meet the deadline, it doesn't matter when you produce it, it's late.
I agree.
Yeah. 15.8
just because, the board said you can apply to reopen doesn't mean that upon the reopening that they're not going to entertain. And plus, this one was a little bit older, I think. This is one of the first cases that came down.
Correct.
So it doesn't mean that they're not going to entertain our argument that it's not timely because it wasn't perfected within the time frame.
My next case is one that I love, though. Najee, please. So, and this really comes after what is an extreme hardship, an independent group home. The core and just the crux of this case is what's an extreme hardship. And my mom has been a financial advisor for most of my life, and so kind of I grew up around the dinner table of, when you retire, kind of setting yourself up, retirement account, all that stuff. And so retirement really is, you have expenses, you have income from these assets, and you have assets, and you kind of run that into the ground and try to hope that that date that you'd run out of money is after you've died. And so just because you have expenses that are exceeding your income doesn't mean that you necessarily have an extreme hardship. That could just be what retirement's like. And in this case, the claimant had a budget shortfall. So the income from her sources and her spouse's sources were less than what their expenses were. But the board found that just because the expenses exceeded the income does not mean that that's considered an extreme hardship.
This is the cat lady rule. You could have 39 cats and have a lot of expenses associated with 39 cats, but just because the expenses associated with keeping 39 cats doesn't exceed or exceeds your income doesn't mean that you have an extreme hardship.
Or again, think about, I mean, I know this is none of our claimants, but think about a millionaire. I mean, if you're a millionaire and you have no income at all for whatever mathematical reason, and you spend 50 grand a year, you still have 20 years worth of money. I mean,
yeah, I love this case too. I mean, this is the, just because you're living basically paycheck to paycheck and there's a short deficit or there's a deficit in your paycheck versus what you're spending money on, which could be the villages and golf cart gas down in Florida, that doesn't mean that you have an extreme hardship.
well, and again, that kind of comes back with the completeness is because they're going to have to substantiate what their expenses are.
Mm-hmm.
And the reason I love this case, not just for that language, is because it kind of brings me back to more family law hoo-ha in the financial disclosure statement. Because if the claimant tries to say that, oh, I have a budget shortfall and it's an extreme hardship because I don't have savings, then okay, discovery of all your financial information, produce that, have fun. And it kind of brings me back to when I was first starting out and going through that big box of discovery to try to track down, okay, what are all these all these people's assets? In addition to, we have surveillance companies we can use, investigators who can check into these things. Where do they have accounts?
And the board has, I think, really evinced an intent that the extreme. I mean, when I said that, the board focused on the word extreme, and they went to the dictionary to look at extreme hardship when trying to determine what the legislature's intent was here. And so this is not just going to be a situation where somebody has a challenging, I think, lifestyle or economic situation because of the limited resources that they have available to them. It's really going to have to be something extreme, which suggests to me that that they would have to be below the poverty level or something along those lines.
Well, and it's not just whether they're below the poverty level or below the self-support reserve. It then puts everything in the frame of case-by-case assessment of, is this an extreme hardship? What are your expenses? What are your incomes and all that stuff? I mean,
and your resources. So if you're sitting in a $500,000 home, but what?
No, continue.
So if you're sitting in a $500,000 home, but you have no income, that's not going to cut it, right?
Depends on part of the state you're in. But
sure.
The reason I just got that giddy little look is that I remember it actually gives us grounds to argue that their expenses are unreasonable. Because if it is that, golf cart in Florida, and that's the reason I can't, that's the reason I need more money is because I want to maintain this, lavish, lifestyle. There you go. Or the people who have excessive, drinking or smoking habits. It's like, do we really want comp to bankroll that when if they just stopped that, they would be fine?
How about if I'm spending $500 a month on Netflix and Hulu and Amazon Prime and everything else that I can think of in order to be able to watch TV about 5 minutes every day?
Well, you're my boss. Hopefully you will not be becoming an extreme hardship anytime soon.
Yeah, we all hope that. So.
But with that, Ajay, if you guys, going forward, what I think this is kind of leading us is that the board's probably going to make it a real pain in the ass to try to get an extreme hardship determination. So more likely you're going to get those situations, at least from my little crystal ball here, where, like in Jeff's case, where they were classified, they subsequently had surgery, they're going to try to come back and say, but I've had surgery, I need a reclassification. And so I see that being kind of more likely than all the hoops the boards can make you jump through in terms of extreme hardship determination.
Sure, I read something in the case law too that said that if you're going to apply for a reclassification under 6A, that it has to be within 1 year of the expiration of your caps. So if it is your position that you've changed from your 76% loss of leisure and capacity to now a permanent total, you have to apply for that reclassification within 1 year of the exhaustion of your durational caps. Yeah. So I taught you something?
You did.
Oh, awesome.
It happens. So also, as I mentioned, I can initially see, before we kind of beat them about the head and shoulders with this, claimants leaving that final section on there, explain why this is an extreme hardship, blank. I see them mostly just filling out the numbers, maybe attaching the documents, but I see a lot of them kind of wasting their opportunity to say why they actually have an extreme hardship. And I can see that as an open door for us to say, Judge, they can't even tell you why this would be an extreme hardship. I mean, we already have the case law that says just having a budget shortfall isn't enough, and without actually completing the form, I don't really see them getting very far.
And submitting the documentation as well. It's very important that they have to submit documentation. They can't just submit the C-35. They have to have substantiating evidence.
Which would potentially lead to some rather math-intensive litigation, which is good for me because I like math.
I like math too.
Thankfully, you're not going to tell that story at that time where you actually were more mathematically correct than me, because
I don't remember that.
It's okay. James told me never to try to cross maths with you. But on that note, we're always here for your questions. And so if you have any questions, I know Jeff was taking advantage of it. If anyone has any more questions for us now, we can field some of those, and you can feel free to get us later.
Julie Powers had a question. Julie says, if a claim is established for multiple body parts and they obtain an SLU to say a wrist and later the neck/back develops, need surgery, and they then obtain an LWEC, can you credit for the prior SLU already paid on the file?
So I would like to field this if you don't mind. So this is one of my favorite arguments, that when you have a back case, you should definitely have an ISO, Claims Indexing Bureau report. I think Julie is specifically asking about when you have a schedulable claim that then morphs into a classifiable claim. But I just want to take this moment to encourage you that if you have a case that's going to end up in a classification, what I'm recommending to clients is that they get an opinion overall on the claimant's entire physical condition at the time of classification. And there are board panel decisions which support that you should take into account all of the claimant's physical impairments at the time of classification. Because if some of these impairments are related to prior schedulable conditions, and you can get your doctor, and again, this is going to take special IME physicians who understand the process here, but if you get the doctor to provide you with an overall severity of impairment, which takes into account all of the body sites for which the claimant may have an impairment, then you should be able to, our position is that you should be able to credit the schedules against what the loss of wage earning capacity is for the non-schedulable conditions. So the board has been very aggressive in finding that when there are both classifiable and non-schedulable and schedulable conditions, that first of all, you cannot parse out the schedulable things. So once the claimant has a classifiable or non-schedule classification, so a back injury, spinal injury, some other, like a psychiatric condition, which is going to lead to a classification as opposed to a schedule, that you can no longer get schedules. So that's another defense that you have. And then secondly, that you take the person as a whole, you don't compartmentalize them into their various body parts. And so many, many times you'd be able to get a benefit of the previous payment against future lost time as a result of the schedule, which for years and years and years we haven't been able to avail ourselves of that. But it's really been a windfall to the claimant. Does that make sense? I know Julie probably asked in a chat, so if not, Julie, then I'd love to talk about this stuff with you, because I really. Okay, great. I think that we are in a brave new world here with being able to take advantage of prior schedule awards. I think that the board has evinced an intent to start to rein in cost to employers by interpreting schedules a lot more narrowly than they've been previously interpreted in the past.
Which I think is a new fantastic point of view.
It is. And I would just also say, as long as we're on that topic, with trends with the board right now, I think that labor market attachment is has found renewed traction at the board, perhaps not with some of our judges that we referenced earlier, but when you take that issue, and of course, I can't guarantee that or anything, but I've just anecdotally, in my experience, I feel like the board is moving to be more aggressive in finding that claimants are not attached to the labor market when they're making searches that are, we all know, BS and not bona fide.
How about, Melissa, how about vested, vocational rehab? I haven't seen anything of that like in 3 years. I've been doing this a long time, so.
I know, and it seems like the easiest way to try and demonstrate that you're attached to the labor market is to participate in Access is the new acronym that's used by the board for its vocational services, and I don't know what it stands for. But certainly if it's likely that claimants don't avail themselves of those services because if they did, they'd actually find work. And I'm not certain that that's always the objective.
I'm actually most likely going to get shot in the face with one of those in another couple of weeks. I think it's adult career counseling, educational services, or something to that effect. But when you actually go and work with Access and do it legitimately, they will identify areas of potential retraining, and so have this claimant who actually has an individualized education plan, setting forth the service he's going to get, the start dates and all that stuff, and that's going to be real fun to take testimony on.
And so in that situation, you're going to bring in the Access counselor in order to substantiate that the claimant is participating to the degree that they say that they are, or you're going to get those records.
I'm going to try.
Yeah. And then the other issue is, and I've seen some really lame, participation in a one-stop service center. The claimant shows up and does one orientation at this, basically it's the labor department's offices where somebody can go and they can use their computers to look for work. There are people there available to help them do job searches on the computers that are there. I've seen some really lame, one orientation participation suffices labor market attachment. And what I'm suggesting to you is that if we were, in the past where you might have felt that was not a viable issue for us to pursue as aggressively as some, maybe we were picking our battles, I do find that the board has renewed interest in this issue, and so we may be able to be more aggressive on that by demonstrating that if the only thing that individual has done is an orientation and hasn't done any follow-up after that you have a good argument, I think, that that's not sufficient under American Axle.
Well, if there's nothing else, thank you for joining us.
Thank you, and we understand we were a little bit late in getting started today. We had a couple of technical issues, but we hope you enjoyed our show. And you can stay tuned. Do you know when next month's is off the top of your head?
I think it's Rob.
It is definitely Rob. We're just going down the letterhead. It seemed to be. I wasn't getting the volunteers that I thought I should be getting, so I solved that. I solved that problem.
So she volunteered us in order.
Yes, that's right. And it's generally the fourth Friday of the month. I'm not sure what day that is off the top of my head, but it's sometime in April. So thanks as always for tuning in, and thank you, Brian, for doing this topic for us. I definitely learned things, and I hope our audience did as well.
It was my pleasure.
Yeah.
Take care.
Things keep changing and never for the best. At least not for you. Rearranging rules that we cannot contest. What can you do? Don't go crazy when the judge says your claimant had a good day. When things look hazy, 'cause there's nothing left of 25A. Don't get angry, get mad today. Gonna help you.
Thank you very much.